Hello everyone, welcome back. I'm Jed Rubenfeld, and today I'm going to be talking about a big Supreme Court decision just handed down yesterday in a First Amendment case involving social media censorship. That case is called Murthy versus Missouri. You probably read about it in the papers. Now look, let me tell you, if you're a firm believer in the First Amendment, as I am, you might be disappointed by that case. It was not a win for the First Amendment. But if you've been following this show, you know I predicted how that case was going to come out, and I'm here to tell you that the fight against social media censorship is far from over. The Murthy case did not reach the merits. It didn't hold that the First Amendment had not been violated. It found against the plaintiffs, but it did so solely on grounds of standing. I'll explain what that means to you, and I got to tell you something else first. I'm involved in these cases as a lawyer. I've got cases all over the country challenging social media censorship. So somebody might say I'm biased. Now, I don't think so, but of course, people who are biased often don't know they're biased, so maybe I am. But here's my promise to you. I will explain the Murthy case straight down the middle, as I always do. You'll understand the facts of the case, you'll understand what the court did, and you'll understand the big constitutional issues surrounding that case. So you can make up your minds for yourself. And we're going to cover a lot of things on this show. I'm going to tell you about the state action doctrine. I'm going to tell you a little something about the constitutionality of vaccine mandates. And if you stick around to the end, I'm even going to tell you about a case that I'm currently involved in where I'm the lawyer that might break through the standing problems that the court identified in Murthy. Okay, let's get started. All right, so Murthy, like I said, is a social media censorship case. And a lot of people ask me, Professor, what does that mean exactly, social media censorship? Can you give us some examples? I mean, after all, if the social media platforms are only censoring misinformation, false statements, why is that even a problem? So let me explain to you what the folks would say who are worried about social media censorship. They would say, that's not all that's happening. That is the censorship of misinformation. The social media platforms sometimes say that they're censoring misinformation, when in fact, what they're censoring is wholly accurate speech or expressions of opinion, sometimes political opinion. Let me give you some examples that the folks worried about this issue would cite to you. First, the Hunter Biden laptop story. I'm sure most of you know what I'm talking about. In the run-up to the 2020 election, as many of you may know, the New York Post ran a story about the discovery of a laptop, which the Post said belonged to Hunter Biden, son of Joe Biden, and contained all kinds of potentially very incriminating material, videos and emails on it. Now, at the time, a lot of people said, that's misinformation. The videos and the laptop itself, that's fake. A lot of members of the intelligence community, former members of the intelligence community said, Russian hoax, it's fake. And the story about that laptop was censored on social media. You could not read about it on Facebook. You could not see it on YouTube. You could not tweet about it on Twitter. They censored it right up through the election. Well, that's one example, because what we found out later is, of course, as you probably know, that laptop really did belong to Hunter Biden. It was not a fake. And that's now been so well vetted and so well established that just recently, the government itself introduced as evidence at Hunter Biden's recent trial, emails and other materials from that very laptop. So that's one example. Let me give you some others. You know, there was a time in 2020 where you could not say on social media in this country that COVID just might have originated in a lab in Wuhan. Couldn't say it. If you tried to post something about that, your post would be removed. If you said it a couple times, your account could be suspended. Now, we don't know for sure where COVID originated, but saying that it might have originated in the lab, that is the expression of opinion which the First Amendment is supposed to protect. Another example, as 2021 rolled around and the vaccines came out, some people started to say that, hey, if you take the vaccine, you can still get ill with COVID. And that contradicted what the CDC was saying at the time. At first, they said, take the vaccine, you can't get COVID. And people would try to post, well, I took the vaccine and the next week I got COVID. They weren't allowed to post it. Again, removed, shadow banned, deboosted, sometimes suspended. And it turned out, of course, that there were breakthrough infections, folks who got the vaccine and still got COVID. Then, similarly, the CDC was saying, hey, even if you get the disease, breakthrough infection after taking the vaccine, if you've taken that vaccine fully, you can't transmit the disease to other people. And people started trying to put online, hey, there's evidence that that's not true. And that was suppressed. Couldn't say it. But of course, it turned out that there was a ton of evidence that strongly suggested that folks who took the vaccine were just as contagious, could transmit the disease just as strongly and rapidly as other people. Here's another example. Vaccine side effects. People wanted to get online and post a story saying, look, my son took the vaccine and a few days later, he started to get these terrible heart problems. And he never had them before. Now, that was simply a true recounting of facts by people who wanted to post those stories on social media. They weren't allowed to. It was stopped. Again, suppressed, deboosted. If they try to do it a few times, accounts will be suspended. Those are examples of social media censorship where the material being censored is not factually false, even though it was often called misinformation. Sometimes it was true, sometimes it was just the expression of opinion. And that's what people are worried about. Now, the question becomes, why would social media platforms be suppressing this true information? And part of the reason a lot of us thought was that the government was telling them to. And that would be extremely important as a constitutional matter. Why is that? Why is it so important as a constitutional matter if the government was involved in this social media censorship? Well, let me explain. It has to do with what's called in the law the state action doctrine. And I'll make it very clear to you. The Constitution and the First Amendment, they don't apply unless you're a governmental actor. If you're a private company or a private person, First Amendment doesn't apply to you. What does that mean? Let me give you a very clear example. Let's say you invite some friends over to your apartment or your house to see a game or to have dinner, and one of your guests happens to express a political opinion that you just can't stand. Maybe it's about a war in the Middle East, maybe it's in favor or against some political candidate. They express the opinion, you just can't stand it. You tell them to stop, they keep saying it. You say, get out of my apartment, get out of my house. And they say, what do you mean? You're kicking me out because of my political opinion? You say, yeah, that's right. I'm kicking you out because of your political opinion. And they say, well, you can't do that. That's unconstitutional. You're violating my freedom of speech. They're wrong about that. First Amendment doesn't apply to you. You're not a governmental actor. It's your house. It's your apartment. You can kick somebody out for any reason you want, including their political opinion. But if you're a governmental actor, you cannot punish a person for the expression of their political opinion. That's the core meaning of the First Amendment. But it doesn't apply to private companies or private actors who are operating independently, no governmental involvement. So if the social media companies were acting totally on their own, no government involvement, there would be no constitutional question. Let me be totally clear about that. Let's say Facebook decided to suppress conservative opinion, all by itself, no government involvement. You might think that's wrong, but it would not be a constitutional problem. It only gets to be a constitutional problem if the government gets involved. Now let me explain a little bit more about that. Sometimes, if the government gets involved in certain ways with a private party's conduct, the private party becomes a state actor for constitutional purposes, meaning what they do is subject to the Constitution. Here's one way that can happen. If the government coerces or threatens the private company or private person to do something, then their action taken under that threat, that pressure, that becomes state action for constitutional purposes, and the Constitution, First Amendment, does apply. Example, decades ago, some state actors in Rhode Island, they started sending letters to bookstores saying, hey, here are these books we don't want you to sell anymore. And if you do keep selling them, we think they're pornographic and we might just prosecute you. You might get prosecuted. And so the booksellers, they were like, okay, we'll take those books off our shelves. And the Supreme Court said, no. When the booksellers took those books off their shelves, yeah, they're private bookstores, but they were doing so because of a governmental threat. They were coerced. That turned their action into state action for constitutional purposes. And so when they took those books off the shelves, that's a First Amendment problem, said the Supreme Court in the Bantam Books case. So coercion can turn a private actor's conduct into state action, but it can also happen without coercion. It can happen if the governmental actors start working closely in a partnership with a private actor. What's an example of that? Well, it's actually very simple. Let's say you're a policeman and you open up the trunk of some car and there's a suitcase there, and boy, do you want to open that suitcase and search through it. But you've got a problem. Fourth Amendment says you can't. Maybe you don't have probable cause. Maybe you don't have a warrant. Fourth Amendment would be violated if you open that suitcase and search through it, so you can't do it. But you get an idea. You see a pedestrian down the street, you say, hey buddy, come here. I'll give you $10 if you'll open that suitcase and search through it. And the guy says, you'll give me $10 if I do that? You say, yeah. And so he sticks out his hand, you shake on it, sure enough, he opens a suitcase and tells you what he sees in it, and you pay him his $10. Well, guess what? That's going to be a Fourth Amendment violation. It's all about how can state actors be prevented from evading the Constitution by getting private actors to do what they can't themselves do as a constitutional matter. Now notice in that case I just described to you that the policeman is not coercing the pedestrian. On the contrary, he's offering him $10. He didn't coerce him. But that's still going to be a Fourth Amendment violation because they entered into an agreement, a partnership. They were working closely together. The law calls that joint action or joint activity. Okay, now that's very important background for you to understand, because a lot of us thought that's what's going on in these social media censorship cases. The government's in there and they're pressuring social media companies and working with them and working closely with them. That's what a lot of us thought. So a number of us lawyers started to bring cases in different parts of the country saying, we think the government's doing this and we think that's unconstitutional. But these cases weren't getting anywhere. Why? Because the judges would say, what's your evidence? And the lawyers would say, well, we need discovery, Your Honor. We don't have the evidence yet because they're doing it behind closed doors, but give us a little discovery and we'll find that evidence. And the judge would say, well, you don't have any evidence yet? And the lawyers would say, well, we don't have a lot of evidence yet. No, because we haven't had discovery. And the judge would say, well, I'm not giving you discovery if you don't have evidence. And the lawyers would say, well, we can't have the evidence unless we have discovery. It's kind of a catch-22. But what's to be said in favor of what the judges were doing? I'll tell you what's to be said in favor. The law says that discovery can't be permitted unless the plaintiffs have advanced a plausible case against the defendants. You don't allow plaintiffs to just go on fishing expeditions on their own say-so. They have to advance a plausible case before discovery will be granted. And a lot of these judges, they were saying, you're telling us that the government's in there telling social media companies what to do and working closely with them and pressuring them. We just don't find that plausible. No discovery, get out of town, get out of court. And that's what was happening, and there was a kind of an impasse. But then this one judge, Judge Doty, down in Louisiana, he broke that impasse. Before him was a case called Missouri versus Biden. That's the case that became Murthy versus Missouri when it finally reached the Supreme Court. Now in Missouri versus Biden, a couple of states, Missouri and Louisiana, had brought suit against President Biden and a couple other federal officials saying, we think you guys have been in there telling social media platforms what to do and putting pressure on them and inducing them to censor protected speech. And Judge Doty says, you know what? I think that's plausible enough. I'll give you some limited discovery. If you don't find anything, you're out of luck. But if you find something, then the case will go on. And that's when the dam was broken and plaintiffs first started getting information about what the government had been saying behind closed doors in its communications with the social media companies. And that was just a start. Because later that year, late 2022, Elon Musk bought Twitter. And he opened up Twitter's internal files and documents to reporters, brought them in and said, look, you go through these and you report to the public about what the government's been saying to us and what our response was in terms of censoring speech. You tell everybody about it and let people decide for themselves whether it was right or wrong. And those reporters started publishing what came to be called the Twitter files. That starts late 2022 and continues into 2023. And after that, a congressional subcommittee got into the picture too and issued some subpoenas to other social media companies saying, we want to see your communications with the government and how that was affecting your censorship decision. Well, you put all this stuff together, what came out and what's now been released to the public, and it told a pretty staggering story. A years-long concerted effort by the federal government to induce social media companies to censor protected speech. It wasn't just a couple federal officials. It was dozens of federal officials at many different agencies and federal entities. I'm talking about the White House itself, the CDC, the FBI, numerous agencies. Federal officials were communicating with social media companies on a weekly basis. They were setting up portals where they could submit their requests or demands for suppression and removal of content. They were identifying specific individuals, specific ideas, specific opinions and facts they didn't want people to see or hear. And the social media companies, not always, but many times, were acceding to these demands and requests, working with them, figuring out what to censor on the basis of who the government wanted them to censor and what the government wanted them to allow people to see and hear. And that's, according to the allegations in the Missouri versus Biden case, that's why the social media companies had censored the Hunter Biden laptop story. Allegations about, or claims about where COVID had originated, and claims criticizing the COVID vaccines and their safety and efficacy. Well, question, why would the government do that? Why would it ask social media companies to suppress true information? Let's be fair. What would the government say? What argument would they make to defend what they were doing, suppressing information even though it was true, even though it was just the expression of political opinion? Here's what they'd say. We were saving lives. They would say, the COVID vaccines, okay, maybe you could still catch the disease if you'd taken the vaccine. Maybe you could transmit it, but the vaccines were preventing many, many people from dying because of the disease, from getting really sick and from dying. And the vaccines, they would say, they were saving hundreds of thousands of lives, millions of lives all over the world. And when people saw the content that the government didn't want them to see, the government's view was, that's going to make people vaccine hesitant. That's the word they used. It's going to make people not want to take the COVID vaccines. People won't understand. They'll see, they'll hear that the vaccines don't prevent you from getting sick. They won't understand that that's different from the vaccines preventing you from dying. And they'll see somebody describing a story about their son having a heart problem after taking the disease. They won't understand how rare that is. And it's going to make them vaccine hesitant, and it's going to make them reluctant to take the vaccine. And it's also going to make them opposed to the vaccine mandates. And the government was very worried about that. The vaccine mandates, the government said, they're saving hundreds of thousands of lives. You remember the mandates, either by law, you had to take a COVID vaccine, or you couldn't go to a restaurant, or you couldn't work at your job without the COVID vaccines. And according to the government, this is saving hundreds of thousands, millions of lives. But people are going to oppose those if they get to see the kind of content that we don't want them to see in the social media platforms. Now, there's plenty of evidence that the COVID vaccines were saving people's lives, that they did save hundreds of thousands, millions of lives. So let's assume that's true. Does that mean that it's okay as a constitutional matter for the government to suppress that speech, even though it might have been true, even though it might have just been a political opinion, in order to save lives? Does that make it constitutional for them to do that? Well, there's serious problems with taking that view, because the First Amendment in the United States has always stood for some fundamental principles at root, and among those are people have a right to know the truth. People have a right to hear other people's opinions and to make up their own minds. And the government's not entitled to suppress true information about matters of public concern, information that's not confidential or a government secret. And they can't take the position that if folks know that truthful information, they'll make bad decisions, because protecting people's right to know the truth and make the decisions they want to make, that's kind of basic to the First Amendment and basic to democracy. So that alone means there's a serious constitutional problem with the government trying to induce social media companies to censor this speech. And there's a very specific problem related to the vaccine mandate. Let me explain it to you. So I told you before I was going to explain to you something about the constitutionality of vaccine mandates, so here we go. You look at Supreme Court cases and other American cases going back 100 years, and there's a pretty strong argument for the following: that you have a constitutional right not to have a vaccine injected into you against your will unless you're at risk of catching the disease that the vaccine's supposed to prevent and transmitting that disease to other people. In other words, if it's just your health that's at issue, you have a right to say, no, I'm not going to take the vaccine. But if you are at risk of catching the disease and harming other people by spreading it to them, then the government can make you take that vaccine. So everything depends, when it comes to the constitutionality of a vaccine mandate, on it being true that vaccine is going to prevent you from getting the disease, or at least, if you get the disease, prevent you from transmitting it, spreading it to other people. The vaccine mandate will not be constitutional if the vaccine doesn't prevent you from catching the disease, or if you catch it, from spreading it to other people. And when it came out that the COVID vaccines weren't doing that they didn't prevent people from getting the vaccine or from spreading it to other people, that undermined the legal case for the vaccine mandates. And this was a very particular but important problem, because the government was in there saying, if we let people understand the truth about the vaccines, they're going to oppose the vaccine mandate. But that's the government saying, if we let people know the truth, they will understand they have a constitutional right to refuse the vaccine mandates. They will understand that it's unconstitutional what we, the government, are doing, that is, imposing all these vaccine mandates. And for sure, the First Amendment does not allow the government to suppress true information that would call into question the constitutionality of government policy. So that was a big deal. Okay, so now you got the government suppressing this speech, and you have evidence that the government's in there pressuring and working with social media companies. So Judge Doty, back in Louisiana, he looks at all that evidence, puts it all together, and he says, arguably, this is the most massive attack on the freedom of speech in United States history. I'm going to repeat that. He called it arguably the most massive attack on the freedom of speech in United States history. So he issued an injunction, preliminary injunction. He said, government, you got to stop that. You can't be in there coercing these social media companies or working in joint action, joint activity with them to suppress protected speech. You got to stop. So the case then went up on appeal to the Fifth Circuit Court of Appeals. Fifth Circuit modifies the injunction a little bit, but basically upholds it. Upholds that injunction. Government, you got to stop this censorship campaign. And then it goes up to the Supreme Court, and it changes its name to Murthy versus Missouri instead of Missouri versus Biden, and the Supreme Court reversed 6-3, throws out that injunction, says nope, plaintiffs lose. But did the court say plaintiffs lose because there was no First Amendment violation? No. What did they say? The Supreme Court threw the case out on the basis of standing. Standing? Professor, what the heck is standing? Well, that's one of these legal terms. Sounds complicated. It's not. It's very simple. You can't go into court unless you're saying that defendants did something to you, injured some right of yours, violated some right of yours. Let's say you're mad that the fast food shop down the street, you think they're not paying minimum wage to their employees. You go to court and you sue they're not paying minimum wage, you say, and the judge says, oh, are you an employee there? And you say, no. And the judge says, well, have you ever been an employee there? No, I have not. And the judge says, well, why are you suing? And you say, well, I'm mad. that. I just don't think it's right. And the judge is going to say, well, get out of town, get out of court. You don't have standing. Okay? So standing means you've got to have suffered some kind of, or alleged that you suffered some kind of legally recognizable injury. Somebody's doing something to you that the law can redress. Otherwise, you can't be the one suing. Now, the Supreme Court said that the plaintiffs in Murthy, they didn't have standing. Why? Well, who were the plaintiffs in Murthy? As I said, the case was originally brought by 2 states. They were later joined by 5 individual plaintiffs. The Supreme Court said none of these people has standing. Why? Well, the states had asserted this tricky thing in the law called parens patriae standing. That's when a state says, we have the right to sue on behalf of our citizens. We have standing to sue to say that our citizens are being injured. But the Supreme Court said, not so fast. There's an exception to parens patriae standing. Yes, sometimes states can do that, but not if they're suing federal officials, which is what you're doing here. So forget that. Get out of town. You don't have standing. Well, what about the 5 individuals? They said, no, we've been censored. These social media companies, these platforms, we posted stuff, they censored us. They blocked our content. They suspended our accounts. We've been censored. That's an injury, right? Well, that is an injury. But here's the problem. The court said, are you still being censored now? And they said, well, no, it happened a while ago, a little bit before we brought suit. And the court says, so you're not claiming that the social media companies are censoring you now. And they said, well, no, that's not what we're saying. Now, if the plaintiffs had been asking for money damages, that past injury, that would be enough for standing. Somebody hit you with their car last year, a few months ago, you sue them, you're asking for money damages. The fact that they injured you in the past, no problem. That's standing, over and done with, easy case. But remember, Murthy versus Missouri comes to the Supreme Court on the basis of a preliminary injunction. That's not a damages remedy. That's the court saying, hey, government, you got to stop doing what you're doing. You got to stop trying to induce the social media companies to censor speech. And there, with respect to that kind of remedy, said the Supreme Court in Murthy, past injury is not enough. You got to show that you're still being censored. How about this, said the court? Can you show us that government officials were targeting you specifically, aiming at you and wanted to censor you? Can you show us some evidence of that? Because if you could show us evidence of that, maybe we'll believe that they're likely to censor you in future. And the Murthy plaintiff said, well, we don't have proof of that they were specifically targeting us. It's the policies they were adopting that were hitting us with censorship. We don't have evidence they were specifically targeting us. And the court said, well, get out of town. You have a past injury and you don't have proof that the government's singling you out, specifically targeting you. You have no standing. Case dismissed. Now, the 3 justices in the minority, they did reach the merits. 3 justices in Murthy did reach the merits, and they said unconstitutional. They said what the government's been doing is blatantly unconstitutional. I'm quoting. But the 6 justices said no standing, never reached the merits. Okay, so where does that leave us? Well, here's where it leaves us. The Murthy opinion doesn't reach the merits, doesn't say there's no First Amendment violation. What it tells us is the door is still open, wide open, to plaintiffs with stronger standing who can still bring the same kind of case and win. And let me tell you about a case that might overcome these standing hurdles that the court identified in Murthy. Because there's a case pending out there right now with a very strong claim to standing, and I know about it because I brought the case. This is a case brought by a few plaintiffs down in Louisiana also. Plaintiffs include Robert F. Kennedy Jr. and a nonprofit organization called Children's Health Defense. And they are saying we were censored, but they're not just saying we were censored in the past. These parties are still being censored even today. Children's Health Defense, for example, has been deplatformed almost completely by Meta, which owns Facebook and Instagram. So they can say, no, our injury isn't just in the past. We're still being censored. And when the courts ask them, is there evidence that you've been specifically targeted by federal officials for censorship? The answer to that question is also going to be yes. In fact, from the earliest days of the Biden administration, federal officials have been singling out Mr. Kennedy by name and asking social media companies to censor him. And there's a ton of evidence of that. So these plaintiffs, they can satisfy both of those demands that the court made in Murthy. They can show present injury, not just past injury, and they can show that the government's been singling them out. And you may ask, well, Professor, why did you bring that case? And I'll tell you, because I was worried about just what happened in the Murthy case. I was worried that the court would kick him out for lack of standing. And I published an article in the Wall Street Journal about this last year saying, you got to watch out. The Murthy plaintiffs might get kicked out for lack of standing. Somebody's got to do something about this. So that's what I did. Brought that case, and that may be the case that breaks this logjam and that finally gets this fully and finally adjudicated by the Supreme Court. Now let me close with a couple of final thoughts. First of all, most importantly, Murthy is a limited holding only about standing. And while standing is important, here's one thing I can tell you. It cannot be the case under American law that the government can get away with constitutional violations based on the idea or the claim that nobody has standing to object to it or bring suit. We don't allow that under American law, and we haven't allowed that for centuries. There's a case decided more than 200 years ago, a little case you may have heard of it, called Marbury versus Madison. In that case, arguably, the case that starts constitutional law in the United States, Chief Justice John Marshall, he said one thing that laid down a principle that has stayed with American law since then. He said, where there's a legal right, there's a legal remedy. That means if a right's been violated, the law has to recognize somebody who can bring suit and get a remedy for that. And I hope that the case I've described to you, Kennedy versus Biden, will be the case that drives the legal remedy here in this case and finally gets this issue adjudicated and ruled on by the Supreme Court, and hopefully gets the court to rule that social media censorship, when it's the result of government coercion or government joint action, is unconstitutional. Now let me tell you one more thing, because people ask me, Professor, why are you so concerned about social media censorship and government involvement with it? And I want to make it as clear as I can. I'm worried about this for the following reasons. In the United States right now, a handful of social media companies have a power over the content of public discourse unprecedented, basically, in human history. No company, no king, no government has ever had the power to control public discourse that a handful of private companies, the behemoth social media platforms, have today. In a way, it's a technological and economic accident. But what's no accident is that the government is going to want to use that power. The government's going to want to get in there and say to social media companies who have this unprecedented ability to control what hundreds of millions of people can see and hear and say every day, government's going to want to get in there and tell them, don't let people see this. Don't let this guy talk. Don't let people express that opinion. It's just too tempting. The government's going to want to get in there and do what the government's been doing, in my opinion, for the last few years. And if we allow that, if the courts allow that, they allow the government to pressure social media companies to censor speech, to work closely with them to identify which speakers are not allowed to talk, which ideas are not allowed to be uttered, which opinions cannot be uttered, which facts cannot be seen and judged by the American people. And we have a real problem in this country. We may lose the freedom of speech altogether. Well, that's all I got for you today. I hope you enjoyed watching. Stay tuned for other episodes of Straight Down the Middle, where I'll be breaking down other important Supreme Court cases the moment they get issued. Thanks and goodbye.
Cause the flag still stands for freedom, and they can't take that